समझ नहीं आ रहा अपने सैलरी इंक्रीमेंट का क्या करूं।
बेटा इतना क्या सोच रहा है? अपने म्यूचुअल फंड्स के एसआईपी का टॉप अप करा ले। दिस इज द राइट टाइम।
क्या? समझ में नहीं आया।
बेटा इतना क्या सोच रहा है? अपने म्यूचुअल फंड्स का एसआईपी टॉपअप करा ले। दिस इज द राइट टाइम।
अब समझा।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
The Adani Group has got its redemption through the American system for the multiple cases in which it was involved or for which it had been arraigned there. To explain this, this is very complicated. I've got lots of notes and lots of printouts. To explain this and to simplify this, we are following the rule of three. We keep saying in journalism that there is something called the three example rule, which means if you get three facts pointing in the same direction, then it makes a straight line. This, however, is a different use of the three example rule. We are trying to break down this story into 3-3-3. So what is the first 3 points? The first 3 points in this process is the 3 cases. Of these 3 cases, 2 are interconnected, one is not connected. One sort of happened, you can say coincidentally, if coincidences happen, or maybe by design, but we'll never know that. But the 3 cases are as follows. Number 1 is the case which was the most serious case of all, because that was a criminal case. America has a law called FCPA, Foreign Corrupt Practices Act. What that means is that if an American company to get business in another country pays bribes in that country, then that American company is liable to be charged criminally in America. That is FCPA. So the first charge against Adani was under FCPA, and that was brought in by the US Department of Justice. And that charge was that the company, quote unquote, or allegedly paid bribes to Indian officials, particularly one Indian official in the state of Andhra Pradesh, total amount being 2,089 crores, or that amount can keep varying depending on the dollar value. At that point, the dollar value was about that much, of which about 1750 crore was supposedly paid to one Indian official in the state of Andhra Pradesh. Who could that official be? It doesn't mention. I will just mention incidentally that at that point, it was the Jagan government, YSRCP government that was in power in Andhra Pradesh. American case therefore was that bribes were paid in India. And why were these bribes allegedly paid? That's because the government of Andhra Pradesh had agreed to buy a bunch of electricity from Adani Green. Adani Green is one of the companies in the Adani Group that, as the name indicates, produces green energy. In this case, this was supposed to be solar energy. And that company was to produce 8,000 megawatts or 8 gigawatts of energy, which the Andhra government was to buy. The little twist in the tale was that in India, usually when people produce energy like this, they find it difficult to sell to state governments, because state governments and state government utilities which distribute power are mostly bankrupt. They are bankrupt because they have to give free power, they have to give concessional power, so they keep on depending on budgetary support. They have very bad credit rating, so nobody wants to deal directly with these companies. For this, Government of India has set up a PSU. This is a centrally owned PSU called SECI or SECI, that is Solar Energy Corporation of India. So a manufacturer of solar energy can go to SECI and say, listen, I have this much power, I can produce this much power at this price, because that will be my price plus my profit, that will make it worth my while, if you find me a buyer for it. It is then SECI that goes out and finds a buyer, which is usually a state government. In this case also, this was a deal done through SECI for 8,000 megawatts or 8 gigawatts by Adani and 4,000 megawatts or 4 gigawatts by another company called Azure Power Global. That was the story. The story then was that because the price of this power was too high, was too much. No Indian state would normally have bought it. Somebody, again quote unquote, persuaded the Jagan government in Andhra to buy it at that price. In return for this, as a quid pro quo, the Adani Group, or Adani Green in this case, they agreed to pay, again, take allegedly as having been read everywhere, allegedly to pay this bribe to Andhra government, of which 1750 crore equivalent was to go to one official. The official was not named in these indictments, but you can figure things out whose government it was. That was one story. Now, if bribes were paid in India by an Indian company to an Indian politician to sell power produced in India, why are the Americans filing cases against that company? The American justification for filing that case and for claiming jurisdiction was under FCPA, Foreign Corrupt Practices Act. It was that while these were Indian companies and Indian promoters, they had also raised bonds in America. And because they had raised bonds in America for their company, these bonds were $750 million, that itself gave them an American connection. That's how they claimed jurisdiction and filed these cases under what is actually quite a dire law. It's quite a tough law in the American system. This investigation was started early in 2024. That is a story that was broken by Bloomberg, also carried by ThePrint. And now it's true that these bonds were raised in America. By about September that year in 2024, these bonds had been redeemed. These bonds were global bonds, of which about $175 million had been invested from America. All the bonds had been redeemed with their interest, etc., etc. It was towards the last days of the Biden government that this case acquired momentum. It was on 22nd of November. Remember, the American election results came. That's when Trump won. On 22nd of November, US Department of Justice opened this indictment against the Adanis. That is Gautam Adani, one of his nephews, Sagar Adani, and a bunch of executives, including one from Azure as well. That is when this became public. That is one side of the story, and that is one case. Now, how do I simplify for you what's happened in case 2 and 3? That is the SEC case and the OFAC case where fines have been paid. So maybe one way is to think of it like a traffic offense. You jump a red light, I hope you don't, but somebody jumps a red light, you get something in your mail saying that you jumped a red light at such and such place, the fine is 1,000 rupees. That is compounding the offense. You pay the fine and the case is over. You don't pay the fine, you can go to court and you can contest it, and then a trial starts. But otherwise, you can pay your fine and compound the offense. That's the kind of process that's taken place both in the SEC and OFAC. Of course, the fine is a little bit more, or maybe more than a little bit more than 1,000 rupees. The second case, it's a completely separate case under a different agency, but is connected to this. And that also in the American system, because it's a capitalist state, takes its markets very seriously and takes its market regulation and corporate governance very seriously. That was a case under SEC, or Securities and Exchange Commission. The first, Department of Justice; the second, Securities and Exchange Commission. What they said was that, look, you quote unquote, allegedly, if you paid these bribes in India, then while raising bonds, you're floating bonds in the American markets, you made declarations or commitments that you had paid no bribes, that you were compliant with FCPA, which is Foreign Corrupt Practices Act. You lied. You lied or you misrepresented your case, and for that you face an inquiry under the SEC Act. So SEC has very tough laws in that area. So that was the second case. But as I told you, connected to the first case. If the first had not happened, then the second would not come into place. Then the third is a completely unconnected case. And that is something that played out over about 3 to 4 years. That was the import of LPG from UAE. A lot of shadow tankers float in those seas, and many of these shadow tankers, which kept on changing their flags often, they brought in a bunch of LPG into Adani's ports. That LPG, US investigations later concluded, had come from Iran. and Iran was under American sanctions. More importantly, any financial transactions with Iran using the American banking systems was particularly under sanctions. So this was a purchase of nearly prices keep varying over time, but at that point, nearly $392 million worth of LPG, and about $192 million of this was transacted through the American financial institutions. So this was another American agency, the third agency, which is called OFAC. OFAC falls under Department of the Treasury, Scott Bessent's department, and this OFAC stands for Office of Foreign Assets Control. So this was a completely parallel thing, not connected to these two. In this also, now a settlement has taken place. Since we are following the rule of three, I have explained the three separate cases to you, two interconnected, one separate from them. Now we know that a bunch of orders have come in. I will first tell you, continuing with the rule of three, I will tell you the three things that these orders mean, and then the three things that these orders do not mean. So three things that have happened are, number one, that US Department of Justice has asked a federal judge in New York to permanently dismiss all criminal charges against the Adanis, Gautam Adani, Sagar Adani, and all the others charged in this case. And they've asked for this dismissal with prejudice. What does it mean? When I read it, I said, with prejudice means, isme kuch qualification hai, no. With prejudice means once you accept this, that means this case can never be reopened. I will read relevant lines from this DOJ note as we go ahead. Right now, briefly, the 3 points which have happened. So all these cases have been withdrawn, and they've been withdrawn permanently. A judge has to rule on it, but as the DOJ note says, that usually judges almost never overrule this. They accept DOJ's filings. Number two, the SEC, that was the disclosure case on the bonds. The SEC settlement has now cleared the Adani Group's name. That has involved a financial settlement. I will give you details as we go along. What this means is that Adani Group's name is now cleared with the US financial regulators, and they can raise investments there, or American investors can invest in their group if they so wish. And number three, after paying the US Treasury a settlement over the Iran trade dispute, Iran LPG import dispute, and by using American banking channels, Adani companies are no longer blacklisted or facing trade bans, and they can again do global business. Remember, when these DOJ cases were on, this was quite a dire situation because these are criminal cases. India may not have extradited Adani to America. In fact, if anything, government of India had not even served summons on the Adanis. It was much later when it looked like the court will rule on the issues of the Adanis not accepting summons, that earlier this year, 30th of January this year, Adani's made a filing in the court saying that they were willing to accept summons by email. What this meant, however, was that for any of these accused, traveling out of India had become very dangerous now. You could travel maybe to China or maybe to Russia, but Americans have extradition treaties with more than 100 countries. So anywhere you went, say in the Western world, you were exposed to arrest and extradition to America. Remember what happened to Nikhil Gupta in the Panu case? He had gone to Czech Republic, and there he was picked up, and in the course of time, after some extradition proceedings, taken to America. For the Adanis, that risk was quite debilitating. That risk is now over because these cases are over. These are the three things, therefore, that happened. The Department of Justice criminal case is gone. The SEC disclosure or non-disclosure issue has been settled. And number three, the sanctions case with US Treasury over Iranian LPG has settled. So these are the three things that these orders mean, briefly. So here are the three things it does not mean. Number one, just because the charges have been dropped against Adani Group, it does not mean that they've been proven innocent, because the case has stopped early. The case has stopped early. Prosecutors have said, we don't think it's worth our while to pursue the case. So it's not as if the judge ruled on the merits of the case and said they are innocent. The case did not reach the judge on merit. The case was not set aside on merit. The prosecutor said it wasn't worth their while. Point number two, So point number 2, the SEC issue. See the SEC order, it's on your screens, and I will share the full order with you, as I will share the full documentation, the DOJ note to the judge and also the judge's order with you. That also you will see on your screens. The second thing it does not mean is pertains to the SEC case. In the SEC case, the Adanis did not admit to any guilt, neither were they proven innocent. The case was resolved and fines were paid without the Adanis ever admitting to doing anything wrong or breaking any laws, nor they having been either accused or cleared. The issue was settled with the payment of money. That's a normal process in America. In this case, the settlement also was not of a very large amount. I will later give you a list of some of the most landmark cases of such settlements in the US, which go into billions of dollars. In this case, Gautam Adani paid $6 million, that's about 60 crore rupees. At today's value, maybe 58, 57 crore rupees. And the nephew, Sagar Adani, paid $12 million, which is about 110, 115 crore rupees today. Once again, for clarity, the Adanis chose to settle the case and pay fines simply to close the matter without accepting any guilt or getting any order of innocence. That's how the American system works. The third pertains to the Iranian LPG import or violation of sanctions charge. That order also neither awards any charge of guilt or innocence. It's a settlement for money. The money is sizable in this case. It's $275 million, which is more than a $250 million. At today's value, almost 2,700 crores. But that case is also closed now. How did this dramatic change come about? Now, first, of course, is that in the US, the government changed. Donald Trump himself has ideologically and principally been opposed to FCPA because he's always believed, and he's said it often in the past, that FCPA actually is a law that makes it difficult for American companies to compete overseas. For example, several European countries would not scoff at their companies bribing overseas, but they will also tax exempt their bribes. So bribes become those companies' expenses which they can claim against their costs of doing business in other countries. And Trump's view is, if I have to compete with Europeans, if Boeing has to compete with Airbus, for example, I'm just using an example, then FCPA puts Boeing or any company in that position at a disadvantage. So he's not been wanting to push these cases. That is one thing that happened. Second, Adani hired a new legal team. This is a very formidable New York law firm called Sullivan and Cromwell, but the lawyer he chose was Robert Giuffra Jr. Robert Giuffra Jr., I hope I pronounce his name right. So besides a $10 billion investment promise, which Department of Justice said had played no role finally in what they went to the court with, they went to the judge with, saying that they did not want to pursue the case. They said that played no role. However, Robert Giuffra's main arguments were as follows. Number one, that there was no proper US jurisdiction. Whatever happened or did not happen was in India between Indians and Indian company, Indian politician, Indian officials, etc., etc. So Americans had no jurisdiction. Number two, there was no evidence available. Number three, there was no strong US link to the alleged misconduct. The bond issue was centered outside the US and nobody suffered any damage. All bondholders were paid back. And FCPA applies only with a real US connection, which Giuffra said was missing. And also that SEC civil case, non-disclosure civil case, and the DOJ criminal case were to be treated separately. Adani lawyers in their defense also used an interesting expression for the charges. They said DOJ's charges are a case of vague puffery. Puffery, you see, puff, you say it's a puff story, jhoot moot, bada chala ke, exaggerated, fictional. So that's what they meant, that these charges are just a case of puffery. These means nothing. I have not seen that expression used in a legal proceeding earlier. That's why I found it interesting and I'm sharing it with you. It's also important to read the original charges that the Department of Justice had brought on. That was the indictment that was unsealed on 20th of November 2024. In summary, we had given you these in great detail in an earlier episode of Cut the Clutter, of which I will share a link with you. Number one, that there was alleged bribery to secure solar contracts in India. Number two, alleged false statements to investors and lenders about anti-bribery compliance, saying that we haven't paid any bribes when you had allegedly paid. Alleged obstruction of US investigations by hiding or destroying evidence, that is called wire fraud. That in America is a very serious offense. DOJ case centered on a large SEC linked solar project and related power agreements, all in India. Then finally, after these charges and defense and arguments that had gone on between the Department of Justice and the Adani Group's lawyers and the presentation by Adani Group's lawyers, the Department of Justice came in front of a judge in a New York court in Eastern District of New York, Judge Nicholas Gorofis, and made a very small presentation. They said the government respectfully submits this motion pursuant to federal rule blah blah blah, requesting that the court dismiss the indictment in this case with prejudice. What does it mean? With prejudice means it can never be brought back now under any form or in any form or under any circumstances. The Department of Justice has reviewed this case and has decided in its prosecutorial discretion not to devote further resources to these criminal charges against individual defendants, and there is a list of defendants. And then they've quoted from an earlier judicial precedent at a high level, saying that, and it's a quote from that earlier precedent, the government may elect to eschew or discontinue prosecutions for any of a number of reasons. Rarely will the judiciary overrule the executive branch's exercise of these prosecutorial decisions. No defendant has appeared. Counsel for all defendants consent to this relief. What they mean to say is that there is precedence in American law that when the executive wants to withdraw a case, ordinarily no judge will turn down that request. And sure enough, the judge has accepted that request and that case is over. The SEC finding, on the other hand, has not gone into merits. The SEC finding says that the Adanis accept the SEC's findings and thereby agree to pay the fine that the SEC has laid. The SEC settlement is a little bit different from the DOJ situation, because in DOJ's case, DOJ has completely withdrawn everything. In SEC's case, the SEC has not done so. On the other hand, the SEC has said that some things happened, you pay a fine of this much and we are done with it. I will summarize it for you because the relevant paras have too much legalese and too much legal sections mentioned there. I will not bore you with that, but you will see the whole document on your screens, and also I'm sharing a link with you. In summary, the SEC document states that Adani consented to the SEC's final judgment and agreed to pay a civil penalty of 6 million and 12 million respectively. 6 million for Gautam Adani, 12 million for nephew Sagar Adani, without admitting or denying the allegations. So that is what ends the SEC case as well. The OFAC case I've told you about earlier. Now, anything to do with a corporate group in India, with big corporate group in India, becomes political, and that applies in particular to the Adani Group. In this case, it's been pointed out, or it's been insinuated that Adani made this deal with Trump because he offered to invest $10 billion. So I will first of all give you a sequence of some tweets, and then you can draw your own conclusions, and then some data on promised Indian investments in the US. On 6th of November 2024, as the American election results came out, Gautam Adani tweeted himself, praising Donald Trump, congratulating him, but using the kind of language that Donald Trump would really appreciate and like. So language like Donald Trump is a model of quote-unquote unbreakable tenacity and quote-unquote relentless determination and much more. That was a pure congratulatory message. On 13th of November, Gautam Adani again congratulated Trump and said the Adani Group plans to invest $10 billion in US energy and infrastructure projects, which could create up to 15,000 jobs. We are in 2024. It is 10 days after that, about 10 days after that, on November 22, 2024, that the indictment has been desealed, that the DOJ indictment has been desealed. We have to understand this sequence of events. Then, as I said, you can draw your own conclusions. Then, investments. The fact is that Indian companies have been investing in America for a long time. Sun Pharma, very reputed Indian company, has just bought a big American pharma company, Organon, for $11.75 billion. That's a lot of money. That's an asset purchase. Other companies have committed to more investments. Jindal Group had already set up a steel business in America, a steel factory, and they are expanding it. Other pharma companies are investing in America. Sergio Gore, the American ambassador, has already said that more than 20 billion have been committed in America. And Donald Trump himself tweeted on March 11 this year that Reliance had committed to setting up a huge refinery in Texas. In fact, he said $300 billion of investment. With Donald Trump, a few zeros can go here and there. But he said that Reliance is setting up this big refinery in America. So he's been trying to draw investments into America. We have to look at the big picture, therefore, and then arrive at whatever conclusions suit us. And finally, I told you that in the American system, financial settlements are quite common for criminal cases as well as regulatory civil cases. So DOJ as well as SEC. And I will give you some examples of the biggest cases. You can go to internet and find many others. Terraform Labs and Doquan, that was the violation. The cryptocurrency platform and its founder defrauded investors by falsely claiming their algorithmic stablecoin. Terra USD was secure and fully integrated with the major mobile payment application. The impact was the stablecoin collapsed. The fine that the SEC charged this company was $4.55 billion in disgorgement, that is giving away their assets, interest and civil penalties. So that is the biggest order. Then WorldCom, 2.25 billion. I will not read out all the details for you. You can see them. Then Wall Street off-channel communications sweep, 2.0 billion. Goldman Sachs, the holy Goldman Sachs, 1MDB scandal, 1.66 billion in 2020. Wall Street research conflicts / global analyst settlement. Again, you will see details on your screen. $1.5 billion in 2003. That was some time back. SEC Capital Advisors, 2013, 602 million. Goldman Sachs, again, 2007, the Abacus case as it's called, 550 million. Wells Fargo, 500 million in 2020. Goldman Sachs, MDB scandal, 2.9 billion global resolution in 2020. These are Foreign Corrupt Practices Act cases. Ericsson, 1 billion plus in 2019. The telecom company, they use slush funds, sham consultants, etc., in Djibouti, China, Vietnam, Indonesia, Kuwait to win telecom contracts. Mobile Telesystems, MTS, that is 850 million in 2019. This company made whatever mischiefs it made in Central Asian republics, particularly Uzbekistan, admitted to FCPA violations and agreed to pay 850 million in criminal and civil penalties to US authorities. Then Siemens AG, the venerable Siemens AG, $800 million in 2008. And this is for bribery in Argentina, Venezuela, next door Bangladesh, to secure infrastructure and public sector deals. Alstom, again a respected engineering company, 772 million in 2014. And this was bribery in Indonesia, Taiwan, Saudi Arabia, Egypt, and the Bahamas. Glencore, the big mining company, 700 million. Again, bribery in Nigeria, Cameroon, Ivory Coast, Equatorial Guinea, DRC, Democratic Republic of Congo, Brazil and Venezuela to obtain oil and commodity advantages. KBR Halliburton, KBR/Halliburton, 579 million, 2008. This was actually bribery in Nigeria using shell companies and intermediaries in UK and Japan. And finally, number 8, Teva Pharmaceutical Industries, the big Israeli company and its Russian subsidiary, they both admitted to paying bribes to officials in Russia, Ukraine and Mexico to boost sales and to get favorable placements. They agreed to pay a fine of 519 million to US authorities. In each case, these companies agreed to wrongdoing, to paying bribes overseas. They admitted to guilt, but they paid this fine and the case was over. That's how the American system works. Just as bankruptcy in the American system is not particularly a blot on you, Donald Trump has been bankrupt multiple times. Similarly, in this capitalist system there, if you get caught violating many of these laws, including FCPA, you can pay your way out of it, and once you admit to your guilt and you pay, then you are done with it. In this case, however, once again, to circle back, DOJ, Department of Justice, did not press these charges. They said it wasn't worth their while to press these charges against Adani. So the Adani case never came to this. The only two cases which came to Adani's having to pay was one, the SEC case, where they paid relatively small penalties, and second was the violation of sanctions on Iran case, unconnected to the first two.